Ms. Mudhoni Gishohi, kindly advise on the composition of your tribunal as well. Ms. Mudhoni, I think she might have dropped off. Oh, she's back. Sorry about that. Technology has its challenges. Oh yeah, great, you're back. Yes, Ms. Mudhoni, can you hear us? You're on mute.
I seem to have disappeared from the screen. I don't know. I have no ideas, but I'm back now.
Yes, it's good to have you back. So perhaps you could also give us a brief of composition of your tribunal, the Retirement Benefits Tribunal.
Yeah, the Retirement Benefits Tribunal, probably I also need to give that background. He said at the Retirement Benefits Act, which came into effect in the year 2000. It consists of the chairperson and 4 persons. The chairperson needs to be an advocate of not less than 5 years studying of the High Court of Kenya, and then we have 4 other members. 2 of them are advocates of the High Court of Kenya, that is James Maboleo and Gideon Solonka. Then we have industry professionals, Veronica Owende and Wageshi Mukoko. That is the composition. Do I need to go ahead and talk about the constitution of, or what was the question? You know, I disappeared from the screen.
Oh, okay. The question was, what is the composition of your tribunal? So you could, like Mr. Joel Bosek mentioned, there are 7. So you could also indicate
yes.
the number.
Okay, we are 5.
Okay.
Okay. Yes, okay. Then let me sorry about that. So we are 5. So, and the quorum for any hearing to take place is the chair and 2 other members. So 3, a quorum would be 3. So if the chair has to be present in every hearing which is taking place for the appeals tribunal.
Okay, great.
Thank you.
Perhaps you could also advise what kind of cases does the retirement benefits handle?
As I stated, we are under the Retirement Benefits Act. The Retirement Benefits Act was supposed to putting together all schemes, all retirement benefit schemes. We have very many different retirement benefit schemes, from occupational retirement benefit schemes, which are set by employers. We have umbrella. There are very many schemes which were out there before year 2000 with no regulation. So the Retirement Benefits Authority was set up to regulate all those schemes. So those schemes now, as I said, are retirement benefits. So they are members who belong to those schemes. There arises different disputes at different times between their members and the trustees of the schemes. If, for example, that you feel that the retirement benefits you're expecting were not adequate, or the way the retirement benefits scheme is being run, you're not happy with it. So if you have any complaints against your scheme, then you lodge a complaint with the Retirement Benefits Authority CEO. The Act has actually given the original jurisdiction to hear complaints on retirement benefits on the CEO of the Retirement Benefits Tribunal Authority. The Retirement Benefits Authority CEO then hears that complaint, he investigates, he goes back to find out exactly what went wrong. He asks people to make representations. He doesn't conduct a proper hearing, but he does his own investigations. People write to him, the scheme writes to him, the complaint, looks at the complaint, and then he makes a decision. Once he makes that decision, and it's on the merits, if you become dissatisfied, if the person who has lodged a complaint becomes dissatisfied with the decision which has been made, because he can make a decision for or against the person. So it for the person who has filed a complaint, or for the or against, which means that is a scheme which has gotten the judgment. So either of those two bodies, either the scheme or the person, if they are that dissatisfied with that decision, they then appeal to the Retirement Benefits Tribunal. So that is a background. But anything to do with retirement benefits matters, they have to go through that process to the CEO first, and the Retirement Benefits Appeals Tribunal next. There has been very many instances where people have filed cases in the employment court, but they have actually all of them been referred back to the tribunal, because that is the law which has been set. So that is now the mechanism which is there. Our appeal, we hear the case as like on appeal on the merits, and then we look at the decision which was made by the CEO. Many of the complaints could be like, my case was never heard on merits. I was never called for a hearing. All those things which are under the Fair Administrative Actions Act. So we look at it, and if we find that indeed this matter was never heard on merits for different reasons, or no real decision was ever made, because he's supposed to make a decision, and it's not a judgment, but it's a decision. We have found out this and this, so that the person knows that my case was heard and the decision was made. So if we find out, we are many times we refer it back to the CEO to hear the matters afresh and make a proper decision, which then, if the people are aggrieved, they can still come back to us. Now, our decision as an appeals tribunal is final on merits. There is no appeal mechanism under the Retirement Benefits Act to appeal against the decision of the tribunal. That places a lot of responsibility on us, so that whenever matters are heard, we go through that whole process: the right to be heard, the access to justice. Everybody, irrespective of their status, we hear them, but we give them their day in court, so that when we make that decision, because we know it is a final decision, and it affects retired persons who feel very aggrieved, because the money they were expecting is not the money they got. So we hear it with a lot of empathy, but it has to be within the law. The trust deeds, they call them trust deeds and rules. They set up how things are supposed to be done. So we look at all those things and make a decision. Once we may make the decision, as I say, to revert it back, although we can make a decision and say this is what these persons were entitled to. Yes, so that is what there's a kind of cases we handle. Thank you.
Thank you. That was very informative, and I'm sure for the advocates who've joined this session, it's also informative to them as well. Filing matters in the right
jurisdiction,
jurisdiction really matters a lot. And thank you for mentioning that instance where some matters are filed in the employment court, which end up being referred to your tribunal. So Mr. Bosek, perhaps you could also inform us, what kind of cases does your tribunal handle?
Yes, earlier on I stated the kind of activities that takes place within the Kenya Accreditation Service, and that it is supposed to accredit the accreditation bodies. So sometimes in the process of doing these accreditations, you find that dispute could arise between the service and the accreditation body. And just to mention also that the chair of the appeals tribunal has to be somebody who is qualified to be appointed to be judge of the High Court of Kenya, meaning that he must practice law for some time. And I'm a lawyer myself. I never mentioned that I'm an advocate of 25 years standing. And I should also add that we have two other advocates, but we have people also who are experts in matters to do with industry. We have a professor, actually a DVC of Masai Mara University, who understand matters to do with the industry. And the tribunal quorum is the chair and 2 other members. So just like my colleague said, the chair must be a permanent member. I mean, in terms of where quorum is concerned. So this is how you file the matter before the tribunal, the appeals tribunal. You write to the CEO of the accreditation service, informing him that you are aggrieved because maybe you are not given the proper accreditation, or the accreditation has been taken away from you, or it has not been renewed. I mean, there could be so many issues that could make somebody, an accreditation body for that matter, to go before the tribunal. And once that is done, the CEO has to alert the appeals tribunal within 7 days. And we already have under this, the third schedule of the act, we have rules on how the tribunal is supposed to conduct itself, much as the law also allows us to come up with our own rules, but there are rules that have been specified. And I want to say that advocates are allowed to represent the parties, and the parties can still represent themselves. And I want to say that the rules of practice under the Evidence Act is said to be admissible. And actually something that cannot be admitted under the Evidence Act, we cannot admit it because the law does not allow us to admit anything which the Evidence Act would not be able to admit. Meaning that the standard of prosecuting matters is a little bit high, unlike other tribunals where the rules of procedure could be bent a little bit. Because you imagine a situation where you are producing some form of electronic evidence. You must file a certificate under the provisions of, I believe it is section 106B there, where you must actually state how you have gotten that evidence and how you have been able to tender it before the tribunal. So the other thing is, should you be aggrieved by the decision of the tribunal? And remember, this is what you will call the internal mechanism. You are allowed to appeal to the High Court, and the jurisdiction of the tribunal is as follows in as far as awarding decision is concerned. First of all, once a party has filed a matter before the tribunal, that party gets an automatic stay. So you don't need to request for a stay of the decision of the service. But once you have filed it, it means that you have an automatic stay. And also when you appeal against the tribunal before the High Court, immediately you file your application in the High Court, your appeal in the High Court. That is supposed to be an automatic stay. You'll be staying the decisions of the tribunal. So the tribunal has the following jurisdiction. It can, one, confirm the decision of the service. In other words, telling you that they believe that what the service stated should be the correct position in law, and therefore we are not going to change it. It can also vary the decision of the service. Number three, it can direct the service to carry out a fresh evaluation based on the scheme. You remember, I mean, during this evaluation of the conformity bodies, the service always must have what is called a scheme in which it will guide it in doing the assessment. Obviously, you will not want a situation where members of the public and all the stakeholders do not have the confidence of a body that is doing evaluation. An evaluation body should be one that it has some kind of international recognition, it can be trusted. It's something that can give people a lot of confidence in as far as when they give a certificate is concerned. The tribunal can also issue other orders that it may consider to be necessary, including an order as to costs. I mean, someone could have really spent a lot of money in bringing the accreditation service into the tribunal. And we know very well that advocates' costs can really be very expensive because, as I said earlier, advocates are supposed or are allowed to make appearance before the tribunal. We are required to make rules, but we were to proceed on some kind of rules making outing. But because of the COVID-19 protocols and other stuff like that, the government told us that we have to wait a little bit. And also sometimes you find that there's also financial challenges. But I think very soon we'll be having the rules of procedure, but it does not stop us to entertain matters. And as I said, the third schedule, for anybody who wants to file a matter, the third schedule of the Act allows you to proceed before even the rules are made and gazetted. I think I've said what I was asked, unless there's a supplementary question. I want to take you back my listeners to the moderators. Chair, I can see you want to ask.
Thank you, Mr. Bosek.
No. No, I am also learning a lot from the chair, Bosek. Yeah, so no, there's a moderator.
Okay.
Sure.
That was also quite interesting to note. At least in your tribunal, we can. You said we can file an appeal in the High Court. Yeah, if I got it correctly.
Yes.
But at the retirement tribunal, the decision is final.
Yes, it is final. As I said, the only way you can then go to the High Court is on a judicial review on the process, but not on the merits.
Okay.
For this one of
okay.
ours, it's so punitive that there's a stay, an automatic stay. Moderator, I've said for our case, it is so punitive that once you have reported us to the High Court, then you get an automatic stay. You don't even need to pray for it.
I think the advocates on board have taken note of that. Perhaps I could also ask, how do we approach your tribunal in case we need to file a case? Do we need formal pleadings? Do we need just statements of the grievances, or how is it really formal? Can members of the public self-represent also in terms of preparing their own documentation, or it's quite intricate that you need an advocate to represent you?
Yes, a member of the public can represent himself. He can also instruct an advocate to represent him or her. And then the rules allow us to receive evidence by way of affidavits. And obviously, you must file a notice where you have to state your prayers. But as I said, you file this before the CEO, which is created by an act of parliament. And the rules, schedule number 3 does not also forbid us from hearing oral evidence. And the fact that there's an advocate means that we could also allow cross-examination by advocates for the tribunal. Remember that not the tribunal, but the board. We have one constant respondent in our matter. The respondent is always the board, the accreditation, Kenya Accreditation Board. And just to say that we can also issue summonses under the 4th paragraph of the 3rd schedules. We can issue notices and summonses. We can summon somebody and, to appear, maybe another, somebody wants to, whom we feel that should be able to testify and enlighten us as to the issues at hand. There is also, that's something that you need to appreciate, or I should bring to your attention, is that the proceedings, as you asked, the proceedings are supposed to be public. Any member of the public can come and attend to the proceedings. So it's open to the members of the public.
Thank you so much. Thank you so much. Ms. Muzoni, how do we approach your tribunals? Do we need formal pleadings?
Yes. I still don't know what happened to my gadgets here. I keep on disappearing. I disappeared again. Yes. And how do we approach the tribunal? As I said, you file an appeal against. Sorry. Let me leave this meeting because I was in two gadgets. You file an appeal against the decision of the CEO of the authority. Now you approach it by filing a memorandum of appeal, which should be filed within 30 days of the receipt of that decision. And I'll tell you more about that issue because the time frame is actually quite short. So 30 days. And once you're supposed to set out concisely the details and the grounds of appeal, and the appeal can be signed, can be filed by the complainant in person or the advocate representing them. The kind of appeals we have is what would actually be taken as a class action suits. As I said, the members who would have a complaint against their schemes could be their scheme members, people who could be retired. So you'll find that most of our appeals actually have over 100 appellants in one suit because their grievance with the scheme is the same because they could all be retirees on a particular scheme. So it therefore means that it will be practically impossible for those 100 over 200 persons to sign the memorandum of appeal. So the person, the respondent is the Retirement Benefits Authority CEO, because he's the one the appeal against his decision, and the scheme could either be named as a respondent there or an interested party. In the event we find persons have only filed against the CEO, we direct that the scheme, because that was the original complaint, grievance against the scheme, they be joined as interested parties. So we hear now the matters from the CEO and the scheme to defend whatever decision had made these people have a grievance. We have rules at the Retirement Benefits Authority, the Retirement Benefits Authority Act. The rules were set when they started. They are not very comprehensive, but more importantly, they state that where any rules of procedure have not been covered, that the rules, the civil procedure rules and the act and rules would be applicable. So there are very many instances where we revert to the civil procedure, the procedure act. So. But as I said, the people can be in person or represented by counsel, and we go out of in fact, the act states that the tribunal, when determining the matters before it, we should not put ourselves in a straitjacket. We should even include evidence which would otherwise not be applicable were it in the normal courts. As you know, the reasons why the tribunal was set up is to have specialized bodies which can hear determine matters outside of the normal court system. So it therefore means that the rules which are applied in the tribunal should not be as strict as the rules in the High Court, which then negates the whole purpose of having the tribunal. It also now obviously have specialized bodies. The persons who are in that tribunal are professionals in that industry, so that to help in making that decision. The tribunal filing fees, for example, as I said, because of access to justice, are very, very minimal. It costs maybe about 3,000 shillings to file. As earlier, people appeal against decisions, so it is not quantifiable amounts because it, as you know, in the High Court, the filing fees are based on how much money you are claiming. So it's usually a very minimal fee, and you have very minimal fee, like 100 shillings for doing copies or filing a memorandum of appearance. Very small amount, so that people can be able to access the tribunal without being closed out because of the cost. So yes, go ahead.
Pardon, I was going to add something on the issue of costs. And thank you for bringing that up, because that was also something I'm sure the participants were going to be curious about, the cost of filing to determination. So you can just finish whatever you were going to say regarding costs, and then Mr. Joel will also let us know how much it would cost to file a matter. Or
yes. As I stated, our basic filing fee for memorandum of appeal is actually 3,000 shillings, and then we have like 100 shillings for filing of appearance. And in the other party, when they file, it's also about 1,000 shillings to file the defense, and there's the statement of facts. But all that procedure is set out in the Retirement Benefit, the rules, the Retirement Benefits Act. We've had instances where lawyers actually approach the tribunal without having really have gone through the act, and we always tell them, go back and look at what the act says. We as lawyers, we know where to find the law, and it's very important when lawyers are approaching the tribunal to know how they approach it, so that the matters do not get unnecessarily thrown out. We have also instances where people file matters. The act says 30 days from the decision of the CEO. We have people filing matters much later without even approaching through an application to admit the documents out of time. So those are there are issues there which I had my fellow chair saying that they are looking into setting up rules. We are also actually in the process of actually amending and updating the rules. As I said, were set up more than 20 years ago. There are a lot of things which have changed, including the new constitution. So there's a process being undertaken right now to update these rules, which will be more in tune with all those issues of access to justice and the things, like as I said, one of the things which is the biggest issue is that the 30 days time frame within which to bring an appeal has been a big difficulty for most people, because by the time the people realize they're supposed to have gotten a lawyer or maybe filed these matters, 30 days are already over. So the cost is very minimal, and when we make decisions, we in the High Court usually costs follow the cost, but we have had many reasons in which we have even if we affirm and confirm the decision of the CEO of the authority, we do not condemn we don't always condemn the appellants to pay costs, because as I said, these are retired persons, and most of them are indigent. They have been pursuing these matters for a long time. They only have a very small pension. If you condemn them to pay costs, then you have compounded the issues which they had. So many times you have actually ruled that each party bears their own costs. Okay. So to avoid having people not accessing the tribunal because of fearing that they may be condemned to pay costs.
Okay. Mr. Joel Bosek, perhaps you could give us insights on the issue of costs in your tribunal. How much would it cost on average from filing to determination?
Yep. Okay, thank you very much. I think I will address the issue of costs, and I'll also address the issue of timings. First, let me start with the cost, because that is the direct question that you asked me. At the moment, we do not charge costs because we have not made rules, and we felt that trying to impose the cost would be actually making rules through the back door. we need to make proper rules, and then that way we'll be also able to ascertain or determine how much cost that will be paid. Filing cost, of course, it cannot be able, I mean, it's not our jurisdiction to impose the cost of advocates, but the filing costs. So at the moment, there is no filing costs. You just do that notice of motion to the CEO plus the affidavit, and then within 7 days, he's supposed to bring it to our attention, and then we are supposed to entertain the matter. But where problem could be, just like my colleague has mentioned, that is that you have to challenge this decision within 21 days. And sometimes 21 days will elapse before somebody approaches the tribunal. And that becomes a problem because remember, it is in the act, it's not in the rules. And something that is in the act, we do not have jurisdiction to supersede it because it's an act of parliament. So if the decision is being challenged, a party must be able to approach the tribunal within 21 days. After 21 days, that of course will be treated as an acquiescence, and that is by the law itself, it's an act of parliament. The rules does not, that is the schedule number 3. Perhaps when we make the rules, we can also like impose on ourselves the deadline of making a decision so that you don't appear before us and then we take like 2 months to make a decision. But of course, obviously, at the moment, we are guided by the fact that every Kenyan is entitled to the rights that is provided for under the provisions of Article, I believe, 47 of the Constitution, which talks about fair administrative actions, where an administrative action must be reasonable and expeditious, among many things. Fair, reasonable, and expeditious. Expeditious means that we should be able to dispose of that matter as soon as possible. And that is what is guiding us at the moment. We can't run away from it. Remember, the Constitution binds all people, juristic persons, and the government as well. So we are always determined to dispose of matters expeditiously. I think I've answered everything, or is there anything that I've missed? So there's no filing cost.
Thank you for that.
There's no adjournment cost as well, or CAF. There are no CAFs as well.
Okay, I'm sure the advocates are glad to hear that. So perhaps we could proceed to the next question. Pardon? Okay. Perhaps we could proceed to the next question. I will ask Mr. Joel to answer this first, then Madam Mudhoni. Are there any rules of procedure on how one should prosecute or defend the case? Besides you've talked about
yes,
pleadings and someone
yes,
can
as I stated earlier on, at the moment, we have not come up with rules, but the third schedules give us the go-ahead to entertain matters without coming up with the rules. And number 1, you can file notice of motion together with the affidavit. But if there are issues with the affidavit, we could, of course, summon the maker of the affidavit and allow the advocate on the other side to cross-examine the maker of the affidavit, just like in an ordinary court. Because as I mentioned, paragraph 2 of the third schedules actually makes it very clear that we cannot admit any kind of evidence which would be inadmissible under the provisions of the Evidence Act, Chapter 80 of the Laws of Kenya. So all forms of evidence that are presented must be one that can be tested and can pass the test under the Evidence Act. Secondly, for the respondent, obviously, if an affidavit has been served on somebody, a supporting affidavit, then the respondent will have to respond with a replying affidavit. And there could be instances where people want to make further affidavits or supplementary affidavits and also further response. So those ones, the rules of procedure, which is provided for under the third schedule, allows us, we have to look at every case on its own merit, and we have to also appreciate that use of discretion is a very important aspect of administrative law, and the discretion must be used reasonably and judiciously. And that's why maybe the law insists on the chair being somebody who can be appointed to sit as a High Court judge. So that is it for the defendant and the applicant. Affidavit evidence is very much admissible, and notice of motion when you are moving, when you are for the applicant, and also now for the defendant, you file a replying affidavit. You can obviously also file a notice of preliminary objection. If somebody has filed this matter outside the 21 days, obviously we listen to you, because outside 21 days, we not have the jurisdiction and we'll have to dismiss the matter.
Okay, thank you for that. Madam Mudoni, I know you had addressed the issue of the rules pertaining procedural rules within the tribunal in terms of prosecution and defense. But I would like you now to just briefly tell us how often does your tribunal sit? Then secondly, have you transitioned into virtual hearings, or are you still doing physical hearings? And a follow-up question thereafter is kindly assist us with the contact of the tribunal. Where are you located? Phone numbers, if possible.
Okay, thank you very much. I had touched on the filing of appeals before the tribunal, but I did not actually touch on the procedure. Once you file, how do you had? So I said the respondent is usually the CEO and the interested party. Both those parties, the interested party and the respondent, are supposed to file their responses, their defenses and statement of fact within 21 days. Then after that, and with all those attendant issues that people get late and they file applications to file out of time, all those, and then we hear them on merits and we make decisions on that. After that, the hearing is then set down. Once we have everything, everybody has filed their papers. We had our hearings through written submissions, and we request everybody to file their submissions and ensure that we allocate time within which to file their submissions. And if you don't file submissions in that particular time, we have had reasons to actually tell them that their submissions will not be admitted because we usually allocate adequate time. So we hear the matters before, and I'll touch about what we are doing right now about physical and online meeting and hearings. Before when we used to have proper, we have a court actually, a proper courtroom set up in Upper Hill. We would set down the matter for hearing and come and have a physical hearing. Their court is big enough, everybody would come in, their witnesses, and we would actually have physical, people would give evidence. If somebody wants to present witnesses, that's allowed. And we would just like a normal court, and they'll be cross-examined, and then people would then submit. And then we have rulings and judgments, obviously, because of the applications. Our turnaround time for doing judgments and rulings is let's say 60 days. That is about 2 months. You recognize all of us. We have other day jobs, so we usually sit. And you had actually asked the question on when we sit. To provide guidance and to meet expectations of the parties who come before us, the litigants and the lawyers, we decided when we were first established in 2019 that we will be having hearings on Thursday morning from 10 o'clock. So all lawyers who represent litigants in the tribunal are aware that the tribunal sits only on Thursdays every week. So and our hearings can go the whole day, depending on how many matters we have that particular day. And as a matter of interest, when I talked about lawyers, we have realized it's only the same lawyers who come before us, and there are a lot of opportunities in the retirement benefit sector. So maybe more lawyers should get into this into this area, because there are quite few lawyers who have matters before us. So as I said earlier, so there are now rules of procedure on how we hear the matters. So if it is not covered out, as I said, the rules were set up a long time ago. So they are very minimal. They're just 12 rules. So we revert to the civil procedure rules on very many of the issues which arise as we are having hearings. So the tribunal is located at the Rahemtura Trust building, where the Retirement Benefits Authority is. We are independent of the authority. As I said, they are usually litigants before us. I can be heard. Huh? Hello? Are you hearing me?
Yes, we can.
Something popped up, a poll question popped up on my screen. I was wondering whether it's the right thing. So we are on the 4th floor. We are independent of the authority, but the authority is housed on the other floors, as we are housed on the 4th floor of the Rahemtura Trust building in Upper Hill. There was another question. Did I miss another question?
You answered the issue of procedure at the tribunal. You answered where we can find your tribunal, and whether you've transitioned to virtual court. Have you done that at the tribunal?
Oh, yes. Now, yes. Sorry. Yeah, that was the issue. I knew I had something else I had not noted. Now, when COVID started last year, as with everybody else, we stopped hearings, which was it was causing a lot of injustices to people whose matters were pending before us. When the judiciary started hearing online on Zoom and on Teams, we also set up the online hearing mechanism, which we were able to set up with the assistance of our mother authority. So we do have online hearings. We started them, I think, around August last year. We took about a few months to find our footing, even to know whether this COVID was going to last for too long. And when we realized that it's going to be a long time, that is the same way as the judiciary. We said we actually set up hearings, and we've been able to successfully hear very many cases. And I would like to mention that since the time we started in 2019, this particular tribunal, we've had matters for over 2,000 litigants. As I said, people file cases, 100 people together. So we've had and determined over 2,000. And we have very many other pending matters before us. So we have not stopped our hearings in the tribunal. We are actively hearing matters, and we hear them on Thursdays every week.
Thank you very much. And the last question pertaining to your contacts is if you could kindly maybe type in
the email. Is it the email?
Email? Yeah.
Email? The email, yeah. Yes. So we are on the 4th floor of the Rahemtura Trust Tower. It is actually right opposite the United Kingdom, the British High Commission in Upper Hill. It's Upper Hill Road. And our email is tribunal filing at rba.go.ke. Tribunal filing at rba.go.ke.
Thank you for that.
Yes.
Yeah.
And let me also mention that our secretariat, which is run by a very able clerk, he's a lawyer, he's called Fred Gekode. ready and available to assist. A lot of people actually go there to find out about a lot of things, and we are responsive very, very well to people's queries, even on email. Whatever you may find, you may even want to know, how do I even start handling matters before the tribunal? And it's not only representing litigants. There are a lot of people who also represent the schemes. Yes, there are also people who represent the Retirement Benefits Authority, because they are all parties before us. So there's a whole wide range of opportunities for lawyers to get, and we are ready and able and willing to provide information on how to approach the tribunal and guidance on that, including litigants in person.
Okay, thank you very much. Mr. Joel?
Yes, I think the question that you are asking could be, is it where we are found?
Yes, where is the tribunal located?
Yes,
your contacts, and if you've also transitioned to virtual hearings.
Yes, let me say this, that unlike my colleague who hears a lot of appeals or a lot of cases from the locals and the retirees, and I want to believe that in a given year there can be a lot of retirees. Ours is actually exercising jurisdiction both within Kenya and outside Kenya. And I mean, it's almost like ISO could come and say that they want us to give them the recognition. I mean, they want the Kenya Accreditation Service to give them recognition. So we, like, it has jurisdiction all over. I think we could be the only tribunal in Africa other than South Africa. We could be the only tribunal in Africa other than, or the only accreditation service in East and Central Africa. So that in Africa, we have in South Africa and Kenya. And you can imagine all those companies that, or bodies that want to be accrediting other companies who provide services and who are in manufacturing. So the jurisdiction is very wide, but the appeals are few. Maybe our service is doing a very good job. Secondly, I want to say that we are also located in Upper Hill. Upper Hill is now the dream of everybody. We are in what is called Embankment Building, and that is on third floor of Embankment Building in the Upper Hill. It's not very far from the Kenya Commercial Bank headquarters in Upper Hill. I'm forgetting the street name, but the email address, you can actually find a lot of details in the website. It's info@kenyaaccreditation.org. Just one word, Kenya Accreditations, then .org. So that's where you can also find matters.
Okay.
Yeah, sure.
Thank you for that. Maybe one last question. You could go first, Mr. Joel, is that where can the decisions of the tribunal be found? Do we find them on Kenya law? Do you have your own site? Do we come physically to your offices?
Yeah, at the moment, you can probably find them in our secretariat. And also, we could, but I think in the secretariat, mainly, yes.
Okay. And
these are not the kind of decisions sometimes which you can find in the Kenya law reporting. I think this is a tribunal, a small tribunal that has jurisdiction over only one aspect. I realized that there was also another question that people might be asking as to why maybe why come to such a tribunal? Why not go to maybe a small claims court or commercial division of the High Court? And if I was to be asked such a question, my answer would be that this is a kind of a tribunal that has been crafted by an act of parliament, whereby if you want to be an accreditation body and your accreditation has not been allowed or has been cancelled or has been suspended or you have problems with the service, then the law only provides for one option, and that is to file your matter before the Accreditations Appeals Tribunal. That should be the answer to that.
Okay. Ms. Muzani, where can we find decision?
Yes, yes, thank you very much. Yes, quite a number of decisions have actually been reported at the Kenya Law Reporting, but for some reason there's a gap, and we are partnering with them to ensure that our decisions are actually readily available to any persons. But quite a number of them, you find them there if you do the search.
Okay.
Yeah.
I think that answers the question on where we can get the tribunals. I will just proceed to go to the Q&A session. There seems to be no question in particular from the chat section, but Cyprian is asking where to find the other webinars that were held prior to this one regarding the Know Your Tribunal series. So Cyprian, please subscribe to our YouTube channel. We've uploaded all the webinars relating to Know Your Tribunal series, including this one will be up by tomorrow. You can also find it on our YouTube channel. Perhaps I'm not sure if the speakers, you have any questions, comments, further comments, just before we wind up.
Sorry, I saw a question which popped up whether we have jurisdiction. I didn't see the whole question. I don't know what. Maybe you can check it.
Jurisdiction.
There is a question where does the tribunal have jurisdiction, and then I didn't see the whole question. I don't know why it could be. I don't know whether it is on charts. Let me see. Yeah, it says, does the tribunal have jurisdiction where a retirement scheme declines to pay the funds to a nominee? That is the question. Yes, I've seen the question. May I answer it?
Yes, please.
Yes. Those are the kind of questions which actually the kind of complaints which are actually lodged before the CEO. If a scheme has refused to pay money to a nominee who has been nominated by that's a beneficiary by the retiree upon their death, for example. I think that is what she's asking. You lodge that complaint with the CEO of the Retirement Benefits Authority, who will then look at everything and make a decision. And if you for whatever reason, if you are dissatisfied, then you have a right to appeal that decision at the Tribunal, the Retirement Benefits Appeals Tribunal. I hope that was enough. I think, let me check. I saw there could be another. Is there another? Let me see whether there's another question. Very informative. Okay, fine. No, I don't know. There's no other question. I was looking at the charts. Yeah.
So there's a poll that has been launched. Please don't end the poll. Just kindly give us feedback to enable us come up with such kind of webinars with more adjustments, and giving us feedback will enable us have information on how we can make the webinars even better for our membership. So please participate in the next 2 minutes. We have 5 questions. We thank you so much for having attended this webinar. It's been quite a journey. We started 2 months ago, and we're here now. So for those who didn't attend, if you're wondering, like Cyprian, where to get the previous recordings of the Know Your Tribunal series, you can go to our YouTube channel. The webinars are uploaded, and you could get more information in terms of jurisdiction, the membership, how to file matters in those respective tribunals. And I'm sure it will save you a lot of time and costs, because some matters are being filed in the wrong courts, and it will actually even help us as advocates advise our clients better. So without any further ado, I am so glad that I'm so glad to have hosted this webinar. Our moderator, our usual moderator, Ms. Namisi, is unwell, and I've been holding fort today. Assisting also on the other end from the back end is Ms. Gloria. And with that being said, if this was a physical engagement, we would have tea, but now that it's virtual, let's just have teas in our own rooms, our own respective houses, offices, and it's Friday. Let's keep safe, and we hope we can engage further in future. Yeah, so thank you, and the meeting is closed.
Thank you so much
you
for
very
this
much.
opportunity.
Thank you.
We wish Ms. Namisi very quick recovery.
Yes, I will inform her.
Yeah. But you did well. If this is your first time to do this moderation, you did very well. Congratulations.
Thank you.
That's why we have been able to score over 80% excellence.
Thank
Yeah,
you so much.
and you know, sometimes you may be trusted on something, and you find that actually I can do it. I'm actually good at it, and you are.
Thank you so much.
Thank you. So thank you so much. I hope as you said, we have clarified quite a number of things, and so that lawyers, there are many other opportunities available for them.
Yeah.
And I have known a lot of things about the accreditation. I'll read up on it. There may be some some opportunity for me as a lawyer to go to engage with the body.
You don't go wrong when you read the law and you understand the law. And
yes,
for lawyers who like reading, they find themselves getting exposed to so many opportunities.
Absolutely. Yeah. Thank you.
And
thank you, Bosek.
Okay, thank you very much, and have a lovely weekend. God bless.
Okay, thank you.
Bye.
Bye.